Well, I think we'll get Tom. I hope gets here. I'll go check on him and then we'll get started.
Okay.
Everyone's here. Tom, how's it going? Nice to see you.
Nice to meet you in person.
Here we have the one. Tim's still missing somewhere in the building, but
Okay.
I think we'll get started. So welcome everyone. I'm Professor Anderson, Jonas Anderson. I teach here at WCL, and I welcome you to PIJIP's ongoing series about the Supreme Court and patent law. As you may or may not know, there are a lot of patent cases at the Supreme Court. In fact, today we heard a patent case, and a patent case was decided, and they announced the opinion on that Apple versus Samsung. But today we're talking about 271F. What does it mean to have all or mostly all the components of a patented invention practiced abroad? So I'll give you a brief overview of the case. Then maybe I'd ask Tom to talk for a minute about his position, and then I'll have Agilent talk about their position of life. But let me first of all introduce the panelists. So to my left is Thomas Sanders. He is a counsel. He practices appellate and government public policy litigation at WilmerHale. Next to him is Irina Roisman. He works for Patterson, Belknap, Webb, and Tyler. She worked on the New York IP Law Association on an amicus brief in this case. To her left is Doris Hines. She represents the Finnegan Law Firm, and she wrote an amicus brief representing the AIPLA in this case. Just barely in the building is Professor Timothy Holbrook of Emory Law School. So he also wrote an amicus brief in this case. To his left is Bradford Paul Schmidt. He's the Vice President of Global Intellectual Property at Agilent Technologies. And very far down there on the far left is John Green. He's at Carter, Ledyard, and Milburn, and he represents Agilent Technologies on their amicus brief. I'll briefly talk about this case. This case essentially started with Deep South. It's a long ago patent case which involved this shrimp deveining machine. And this shrimp deveining machine was made in multiple parts and shipped abroad and then put together. And in patent trials, they found that not to be infringing. And Congress said, well, we don't think that's right. And so they passed 271F to kind of close the loophole that was created by Deep South. 271F1 is the statutory provision we're dealing with in this case. And it says, whoever without authority supplies or causes to be supplied from the United States all or a substantial portion of the components of a patented invention. So that's the key phrase we're dealing with today. What does it mean to have a substantial portion of the components of a patented invention in such a way as to that would infringe the U.S. patent if it occurred in the U.S. is also infringing the patent. So it's a small exception to the extraterritoriality issue of patent law, saying all patents are territorial. All U.S. patents only cover the U.S. This is a small provision that says, well, even outside the U.S., we're going to capture some activities that occur partially outside the U.S. and call that patent infringement. And the question today really is, how much do you need to supply to have a substantial portion of the components of a patented invention? In this case, we're talking about Taq polymerase, which was the molecule of the year, 1989, according to Science magazine. And it is the one component that is supplied from the United States in this case. It's one of five, according to this case, which of the components of the patented invention. But it is a big portion, according to some. And is that enough? Is one component enough to meet the statutory requirement for all or a substantial portion of the components of a patented invention? So that's the case in a nutshell. So I'll turn it over first to Tom to give your brief version of your argument today, and then we'll go from there.
Sure. Thank you. Thanks for having me. So our view of substantial portion was that this is a flexible concept and can consider a variety of factors. And what we were doing in this case is defending the jury verdict. So this question went to the jury to find it was a substantial portion of the components supplied from the United States. The evidence at trial showed that for a big chunk of the kits, actually, there were two components being supplied from the U.S., and for the remainder, it was the one component, the Taq. There was also testimony at trial about what the various components did, and discussion among the witnesses about their importance, including some concessions from the other side's witnesses about the importance of the components being supplied from the United States. So our view before the court and our fundamental position was that the question of whether a substantial portion has been supplied is a fact question for the jury to determine, and it can determine it by looking at a variety of factors, which would include not just the number of components, but also the importance of those components, and that what the Federal Circuit did here was just engage in substantial evidence review of that jury verdict. And so what we are pushing back against in this case is, one, a strictly quantitative rule. The argument being made that says, because this is all or a substantial portion of the components, the words around it are speaking in quantitative terms, so we would have a strictly quantitative rule. And we don't think that the rule is that inflexible. And the example we give is, imagine a patented pill that has one active ingredient and a few inactive ingredients. It would be a strange rule if you were just counting components that you'd be saying that all that matters is the number, regardless of whether you're supplying a really important component or not. And this would have perverse results, not only in terms of leaving a gap for the patent owner protection, but just think of it from the defendant's perspective. If you supply the three inactive components of the drug, and someone's saying you supply a substantial portion, if you have a strictly quantitative rule, you wouldn't even be allowed to defend on the ground of, hey, what I was supplying wasn't the important piece. So we say it's a flexible rule. And then the other point is, even though the Congress began by responding to the Deep South situation, the actual structure of 271F is not based just on trying to capture almost complete manufacturing in the US, but instead Congress went to a different structure, which was it drew on principles of induced and contributory infringement and enacted two provisions that are mirroring those concepts. And so we think that you sort of can't lose sight of the fact that an important part of 271F one is the fact that you have to have active inducement. And so what Congress is targeting is that encouragement or scheme or provision of instructions, whatever it is in the United States. Unlike the domestic version of this, words alone aren't enough. You can induce under 271B just by encouraging somebody, just by providing instructions. Here, you have to go beyond words and actually be materially facilitating through your component supply. But we think when you look at that structure, you shouldn't read sort of all or a substantial portion in isolation as if it's the only safeguard here, because it's part and parcel of this inducement provision, and the sort of gravamen of the wrong that's being done here is the inducement. And this is certainly in the statute. It's a check, but it doesn't have to be read in a rigid way that essentially is replicating complete domestic manufacturing, except for the final assembly.
Great. So maybe I can ask Bradford to step in the shoes of Life Technologies and give us what's the argument that Life Technologies made today in response to Promega?
Yeah, so in essence, I should say, why am I representing Life here for this webinar? I was actually head of litigation at Life when this trial happened. I was there in Madison, Wisconsin, on those very cold February days and nights when we actually tried this case, and was very involved in the J-Malls and other motions that eventually led to this case being here at the Supreme Court today. I'm with Agilent Technologies today, though, and we filed an amicus brief, which is the main reason why I'm here today. But speaking for Life for the moment, Life's basic position is that substantial portion means a large percentage, closely approximating all. And it bases that construction on basically four things. First, the language of subsection F1, the relationship between sections F1 and F2, the principle of extraterritoriality and the presumption against that, and then finally the purpose of the statute. So according to Life, F1 is really applying to the Deep South situation where all of the components of the patented invention are manufactured in the U.S. and then shipped abroad for the relatively trivial step of assembling it into the final invention. Under that construction, a single component, at very least a single component, simply is not sufficient under F1. You need at least two components, and then according to Life's position, you really need something closely approximating all of those components. The single component situation is one that would be covered by subsection F2. And the notion is that F1 and F2 are complementary in what they cover. F2 is the one that specifically addresses a single component and provides specific restrictions on what type of single component can suffice for finding infringement under this situation. One example is that F1, according to Life's position, F1 uses the plural components consistently, whereas F2 uses the singular component. And while that may not make a difference if you look purely at the Dictionary Act, if you look at the two statutory provisions together and understand that they were written together as complementary provisions, that distinction actually makes sense, and it actually is in harmony between the two sections. Looking at the extraterritoriality aspect of it, the notion here is that there is extraterritorial conduct that's being regulated because a portion of the statute relates to what's happening outside the United States in terms of assembling something that would infringe if it had been assembled within the United States. It also has an impact on what people do outside of the United States because they need to be careful under the statute with what they source from the United States, because it's been stated, I think, by the German manufacturers amicus, when you source something from the United States, it carries with it an infection of 271F that can contaminate what that company is doing outside the United States. So what Life says is that in light of those extraterritorial aspects, that you have to construe this narrowly in order to construe strictly in terms of what the language actually says, and you have to understand Congress's intent from the language that it used. In terms of the purpose of the statute, Life interprets it as referring really in F1 to the Deep South situation, and the purpose was to prevent this sort of end run around the patent statute by making all the stuff in the United States, but then escaping infringement by just a hair's breadth, by then shipping the stuff out and having it assembled offshore. The difference is the assembly is trivial. And if you assemble in the US, you're tagged for infringement under 271A because you made it in the United States. But by doing everything else, all the hard work, all the value add of making all the parts, and then shipping it out, you escape infringement despite that huge US connection. And then finally, I think what life's looking for is some sort of a decision. What does this statute mean? Because a jury needs some guidance. And whereas Promega's position is we can leave it to the jury to figure it out as a factual matter. What life is looking for is, well, give us some guidelines. What do these words in the statute mean? What should the jury be looking for? We need something. And I can tell you from having been at the trial that would have been very useful to have some guidance as to what these words mean in order to let the jury know what should you be thinking about, what's really included, what's not included here. So that's the essence of life's position.
Great. So maybe Doris and Irina, you can tell us why are your organizations so interested in this case, and what's the position that each of your organizations takes in this case? Let's start with Irina.
Okay. Well, the NYIPLA is very interested in a strong patent system that protects and promotes and fosters innovation. And so the brief that was filed was and many of the briefs that the NYIPLA files are part of that important effort in promoting patents and innovation in the United States. And we thought this brief and the issues here were particularly important because many inventions are multi-component inventions, and many inventions are two-component inventions. And in this particular case, Life Tech was arguing for basically a rigid numerical test and to categorically exclude the supply of one component from the United States as resulting in liability for infringement, even assuming all the other elements are met, where the combination occurs abroad and there's active inducement and all of those things. And so that raised a significant concern as to two-component inventions, and in fact, as to 3 or 4-component inventions, depending on how you construe the rule. And so we thought it was very important to do exactly what the Federal Circuit did here, which is reject a categorical rule and allow juries to apply the test flexibly and to consider all the various factors in coming to a determination as to whether the substantial portion requirement has been met. So that was one piece of it. Our other big concern was that a numerical rule would encourage all sorts of gamesmanship. So if there was a categorical rule that said, if you're supplying one component, you're off the hook, then, for two-component inventions, you're done. And but also you can imagine situations where, as a result of such a rule, exporters become inspired to combine all sorts of things before they ship them out into one component, or they divide up between different exporters what's actually exported out. Again, it's just simply a way of avoiding liability and playing this numerical rule. And we thought it was important to protect innovation and not encourage that, and that a numerical rule would. And another big incentive, and something that the brief spends a lot of time on, is the issue of extraterritoriality, because we felt that in this particular case, the presumption against extraterritoriality was being both misapprehended and misused. There is such a presumption, but it works in a completely different way than being advocated here. So what's being advocated here is that Supreme Court, please, when construing language, when doing anything, minimize the effects of your construction on trade. Well, the Supreme Court's not really equipped to do that. That's not what its job is, and that's not the right thing. And this presumption goes back more than 100 years, and it works in a very different way, and that's to determine the geographic scope of regulated conduct. So if you see a regulation or statute and it's talking about a crime, the crime is X, the statutory canon is that the crime that's being discussed is one that's committed in the US as opposed to Brazil, and that's the rule of construction. But there is no rule of construction that you basically construe statutes to minimize their effects on trade, and we felt that was inappropriate and that was a very important issue to address.
Doris.
Sure. AIPLA is this nationwide organization, 14,000 in-house and outside IP professionals believed it was important to have their views heard on this issue of statutory construction and also how it fits in with other areas of patent law. With respect to the issue of substantial portion of the components, the view of AIPLA largely tracks, I believe, the views of New York Intellectual Property Law Association, in that it is not primarily a quantitative assessment. Instead, it should consider the quantity of components when you're looking at what was sent from the United States. So that should be a factor. But certainly the qualitative assessment of the importance, the significance of what was sent from the U.S. should be considered as well. And think about the kind of test to apply, and that was addressed a fair amount today. Well, how do we decide what a substantial portion is? In our view, you can look at other areas of patent law, particularly, for example, the Supreme Court's jurisprudence on patent exhaustion, where you look at whether or not what is made substantially embodies the claimed invention. So it doesn't have to be everything. It needs to be what's important and what substantially embodies there. In the Quanta case, and a finding of exhaustion was upheld, although not everything that was supplied was in the claims, was what was in the claims. Some of the things that were more generic components were not, and yet a finding of exhaustion was upheld. And I think in much the same way, when you look at whether a substantial portion of the components are supplied, you can do that kind of similar analysis. AIPLA also suggested in making the determination of whether something is a substantial portion, you go back to the specification. Look at the tenets of claim construction and how you look at what's claimed and consider it in light of the specification, and was it considered important, significant, and how you make that assessment. The assessment would be made by the jury, but the view was that there are enough guideposts in the law now that can be applied to a 271F analysis in order to have the jury make that decision in a satisfying way. I guess another point is with respect to the quantitative, and one component can never be enough. The view was that kind of bright line rule of always eliminating one component is, one, recently the Supreme Court has been rejecting those kind of bright line tests in patent law and has done it fairly routinely recently in Octane, KSR, and other cases. And it should not be adopted here either. But that the analysis of never one component, if you look at specific claims where one component is extraordinarily important and the other ones are fairly trivial, then you would exclude liability always in that situation, which I think is inconsistent with 271F, as drafted.
Great. So before we jump into what happened today, Tim, you've written a lot about extraterritoriality, and that's come up a little bit today. Can you tell us a little more about that and what your views on how that should be applied in this case?
Sure. So I wrote an amicus brief as well, both at the cert petition stage and at the merit stage, focusing on the extraterritoriality question. It's something that I've written about extensively in my scholarship. And I think institutionally, the Federal Circuit has at best applied the presumption inconsistently. In fact, if you look at the decision in this case, no one mentions it except the dissent. And so I thought that was problematic. And so here, the argument today, particularly when petitioner was arguing, there's quite a bit of discussion about extraterritoriality. It is an issue the Supreme Court is interested in far beyond patent law. So I think that's part of how this case got there, is that the Supreme Court is interested in extraterritorial limits of U.S. law, period, regardless of patent. So it's their example of, patents aren't different. I think that the Chief Justice had an interesting question. This goes to the position of New York IPLA today, where he said, well, look, we just recently had a case, right, where it's either it's extraterritorial or it's not, and it's done then, right? The presumption doesn't go into the minutia of the elements of the statute. And the case he was referring to, he couldn't remember, was RJR Nabisco, which was decided this past term. And there we finally got a test from the Supreme Court on extraterritoriality. It's step one, you do an analysis of the statute itself to determine whether it applies extraterritorially. If it does not, then you're not finished. Step two, you look at the focus of the statute and determine, well, even if there is a domestic act that is the focus of the statute, could there nevertheless be extraterritorial parts that extend out from that are appropriate to regulate? And so these cases have come up in RICO cases and securities regulation. And so that, I think, is what he was referring to today. But the response, in my response to the New York IPLA position, is that's not what Microsoft versus AT&T said. All right, Microsoft specifically said, yes, 271F is an extraterritorial provision explicitly. So under RJR, you would satisfy step one. However, as a matter of statutory interpretation, you still use the presumption as a background tool of construction so that in some sense, if in doubt, go narrow, because we want to try and mitigate and minimize potential risks with foreign sovereigns in other countries. And so Justice Kennedy today made allusion to, does the UK have a patent in this? Has the patent expired? So that clearly is illuminating some of the justice's thoughts in this case, that even though we have this domestic nexus of exportation, that there is concern that U.S. patent law is then meddling in these foreign markets in ways that could be dubbed inappropriate by those other sovereigns. So I think it is in the minds of the court. I think it's in the minds of the court beyond patent law. And I do think in this case, it is appropriate to think, look, maybe we should err on the side of a narrower interpretation in the face of an ambiguous statute to make sure we minimize those extraterritorial concerns. Now, my brief offered my own wacky academic view of how we should deal with this. I actually think we should look at potential conflicts of law, and if there aren't conflicts, go right ahead and find infringement. They're never going to buy that, even though they sort of softly do that in all their analysis, where you look at RJR Nabisco, you look at Morrison versus Australia National Bank, actually think about those things. It's just not formally part of the analysis. So I do think that presumption is lying in the background. I think those concerns of reach are driving why the court's interested in some of the concerns, as echoed by Justice Kennedy. And you see even the Chief Justice with his question recognizing that this case links up to Morrison and RJR Nabisco in the broader sense.
Great. So lastly, John, why don't you tell us about your brief was mentioned in the court today by name. That's always a pleasure for anyone who writes an amicus brief. What do you think it was about your brief that attracted Justice Kennedy to it, and what was your position in the brief?
Well, the brief of Agilent Technologies as amicus was rooted in in our understanding of our unique perspective, or our perspective on the case, which was very much a business one and very much a one that was focused on the practical implications of the decision of the panel in the Federal Circuit decision. So first, we thought it would be helpful to educate the Supreme Court about what the global supply chain looks like today. Agilent is a good example of a global company. It has about a third of its business each in the U.S., in Europe, and in Asia, and the decision that was at issue here raised a rule of law which brought into question the possibility that shipping a single component outside the U.S., which is something that happens many times in the course of a year, might in turn require patent attorney attention to the implications of that shipment. And so we spent some of our brief talking about the implications that would have for a business in trying to understand and manage that risk. And the point we made is that is a very large risk that would be hard to manage. We decided to, working with Brad, we decided to file our brief also at the petition stage, because we saw this case as one that was worthy of review, and we thought our perspective from a business point of view would be useful. On the merit stage, we also wanted to educate the court more about the history leading up to the Deep South decision. So the Deep South decision didn't come out of a black box. It was the result of several years of civil court decisions. At that time, there was no federal circuit, and so different circuit courts were coming out with different rules, and that was then endorsed by the Supreme Court in the Deep South case. And so that background, we think, also informs how you should understand the words that were chosen by Congress in 271F. And as an author of the brief, I was very pleased to see Justice Kennedy recognize the work that we did, because he did call out the brief for exactly the points we were trying to make, that the global supply chain is much different today than it was when 271F was announced, and that there's some real business issues that need to be considered. We thought it was appropriate for the Supreme Court to consider these policy issues, just as it considers extraterritoriality and other policy issues in deciding how to interpret statutory text.
Great. So let me turn it over to the panel and just ask for impressions of the argument today. Everyone was at the court. So I thought it was very interesting that the justices were so involved. Every justice asked a question to both sides, I think. Maybe Justice Kagan didn't, but they were very in the weeds with the issue. And that's kind of surprising. So maybe you can comment on that, or something else you found intriguing about the argument today.
Well, I'll start off, which I thought the most interesting part of the argument was the government's period of arguing, because what had happened in this case is the court had called for the views of the Solicitor General at the cert stage, and the United States had come in and said, yes, we think you should grant and reverse. It then wrote a brief that I think most people thought was aligned pretty closely with Life Technologies in terms of focusing on a quantitative rule. But at oral argument today, what you heard from the government was, no, actually, it's not quite that rigid. And suddenly there was discussion of a lot of other factors in terms of how you might assess a component. And I think that this really got the justices' attention, because they began asking pointed questions of, well, why would we consider A, B, C, and D, but not consider the importance of the component? So I think that you saw what had previously been a sort of pure textualist argument and this wall of, oh, it's quantity only, being breached at argument, which then left the question of, well, if it isn't going to be purely quantitative, then where are we here? And that created a good opening for us to come in and say, where you are is that this is a fact question for the jury, and this is like so many other questions where, it can go with instructions and guidance, but on some level, the rule of law, that the standard can only take you so far, and then is going to have to be applied in individual cases.
I was surprised. I think that was a surprise as well. I think the court is struggling with the issue of, okay, what guidance can we give without throwing out a baby with the bathwater necessarily, and without sort of causing disruptions downstream. I think they don't know the answer. I think my read was that they wanted a quantified approach, but they can't say 80%. They can't give a number, and so they're trying to figure out how to meld those two. It wouldn't surprise me if they try and embrace, which is typical of a lot of these cases, what the government said, because they seem to be trying to, the Chief Justice wasn't having it, right? But there's trying to be some rehabilitation of what was going on. And so I think that was a little bit more surprising. I was most impressed with their facility with this text of the statute and the statute itself, right? That sort of the petitioner pitched this as a trade case, or different ways of pitching the case as not really being about patent law in some ways. And I get why you would want to do that to the Supreme Court. And it's not they rejected it. There was no need, right? That they really were. I mean, we were talking about claim construction at one point. Who would think that a 271F case would bring up issues of claim construction? Quanta came up, right? That thinking of this idea that there's some sort of invention out there that is separate from the claims itself that we can use to somehow mark out and delineate what is of value in the invention. And so it really went beyond statutory text. It went into some of the weeds of patent law in a way that I've never seen a Supreme Court argument go before. And maybe it's because it was the only case today, who knows? But it was impressive. I didn't walk out fearing for patent law regardless of the outcome, as I have in many other Supreme Court arguments.
I agree with that. I'll just add, I thought it was terrific that the focus seemed to be so much on the statutory text, though, instead of focusing on, while considering policy issues, not considering them in the abstract, considering them in light of these two statutory provisions, and whether you agree or not that they're complementary, I think there's an argument there. But they seemed to be so focused on what the words were there and how to interpret those words while considering the policy issues at the same time. So I have to say I was heartened by that focus.
Yeah, a little bit of Justice Scalia's ghost was in the room.
Particularly talking about legislative history, but I'll leave that alone. Right?
So one observation following up on this was, in contrast, I think, to some of the other recent Supreme Court cases where there have been rigid rules rejected, I think this is a very different case, because in this case, we have a different issue. We have a statutory interpretation issue. You don't really have that the same in KSR, for instance, and some of the other Supreme Court cases. This is a case that begins and ends with the language and the words of the statute in a way that I think the other cases haven't. And I think the justices, with their questions, were very focused on that. And a couple of the questions that came up, for example, I think it was Justice Kagan asked, if I said a substantial number of my former clerks have gone into private practice, how many would that be? Well, there's really only one good answer to that, and it's going to be a quantitative answer. It's not the quality of the people, it's not the type of practice, it's a number. And by the same token, I think it was Alito asked, if I asked what is a substantial portion of the pages of your brief, again, the answer is quantitative. It's a number. It's not about the importance of a given page versus another page. And so I think that's why the emphasis on the statute, because that's what this case is about. And that's why I don't think it's an issue of them wanting to reject a rigid rule that's been imposed by the Federal Circuit. I think maybe this is the opposite. Maybe this is where they want a more rigid rule. Rigid is not the right word. Let me take that back. They want a rule. They want something here based on the statutory language.
It feels a little bit more like an older case, FAF, where that was one where they actually, it's bizarre to say here today, right? But they criticized the Federal Circuit for not giving enough guidance. And they said this totality of the circumstances test for the on-sale bar is no good, and here's a better test with more guidance. It did have a little bit of a vibe of that with less, but you're right, this focus on what does substantial mean, and what does it mean in this context? What does it mean in other contexts? What does it mean in terms of, those examples, which are more sort of vernacular examples, right? I think they're really struggling with how to define that term in this particular statutory context, but with a focus on the statute.
So let me for the students out there, let's talk about Supreme Court strategy. So both sides wanted to frame the case in ways that advantaged them. So Tim talked about the one side, Life Technologies wanted to frame the case as a trade case. I think Promega came out and started talking about 271F1 and 271F2 as parallel to 271B and C. And the court, I think it's fair to say for both those issues, the court kind of rejected the framing and wanted to talk about the words of the statute. So maybe Tom, you can walk us through how you approach the way you're going to try and frame the case up at the Supreme Court, and ways you can do that are more effective and less effective.
Yeah, so I think a lot of it depends on the procedural posture and what you see, because of course the side that's the petitioner usually sees the broad question of law, and they're saying there's a question of law for you to decide here. The side that has won below is usually happy with the status quo. In this case, we were not only the side that won the federal circuit, but we had won at trial. And so one of the ways we tried to frame the case, in addition to saying that they're actually wrong when they're talking about this is essentially domestic manufacturing and trying to say, no, Congress went in a different direction here. Look at 271F2. There, we know supplying a single component can lead to broad liability. And so we tried to make the court see that there was a different frame being applied there. And then in terms of the jury verdict, saying, there's a spot beyond which the court doesn't have to get into it because it was the jury's decision. So the question here is just whether no reasonable jury could have reached that decision. And so that's what ends up with this framing of the rigid rule or not, is that we say that this other side strategy for saying ignore what the jury did and override this as a matter of law has to be because there's some clear rule they're finding in the statute. So as long as we can poke holes in that and say it's not unidimensional, it's not just quantity, more can be considered. Once you've breached that firewall, or whatever metaphor you want to use, then it becomes multi-factored and the deference to the jury really kicks in.
And maybe Brad or John can comment about what Life is, why Life's trying to frame it as a trade case, and what goes in. I mean, you weren't the arguing today, but maybe you can tell us why you think Life's trying to do that, and what advantage that has to frame the case as a trade case.
Well, I think. I don't know, but I suspect that they were really trying to emphasize the presumption against extraterritoriality. And they were trying to draw in probably Agilent's brief as well as the German manufacturer's brief. And in fact, I thought that the trade case notion got a little bit of traction, at least, because I think it was Justice Breyer, who was asking, is it against the law to send instructions to the UK? Here's how to make an invention that's patented in the US. Is it against the law to do that if it's not patented in the UK? And the answer is, well, no, you can do that. There's no law against that. And then Breyer then framed the issue from that perspective and said, well, then the issue here then is what are the limits that Congress is placing on that which is otherwise not unlawful? And that, I think, was the frame of reference that Life was going for there, was let's start with, it's basically the same thing as let's start with all components. Let's start with the egregious case and then focus down from that a little bit, but not too much.
From, just speaking from the perspective of Agilent and what we were trying to do in our brief, it really was a very practical approach, because the implications of this rule raised a lot of flags when you consider how much commerce there is among countries. And you really do have to think about how you're going to do what you've committed to do, which is to respect intellectual property rights. I mean, all companies devote, substantial attention to making sure that what they're doing is lawful under the patent laws as well as the laws of the countries in which they operate. And the implications of this rule and the way that the jury was given the freedom to use whatever definition of substantial portion they felt made sense raised a big risk because of the uncertainty of jury verdicts, because of the flexibility with all the different things you could argue are part of what substantial means. And that's why even at the petition stage, we thought it made sense for the Supreme Court to come in and try to provide some clarity, particularly where the Federal Circuit split in its decision. While the dissent didn't write specifically on this issue, it does show that this was not as clear an issue as it should have been. A JMOL was granted below on this very issue, and so it did merit, we thought, Supreme Court attention.
Great. So maybe we'll turn it over to any questions anyone in the audience has. Yeah.
I believe Justice Kennedy addressed the issue of flexibility, and he asked whether it made sense to have such a loose rule when there may be other countries whose patent laws are so different from ours. Could you address Justice Kennedy's comment?
Sure. I mean, I think that it's legitimate for the court to explore some of these policy concerns. At the end of the day, I think it proved inconclusive because the other side was saying, it's very important, and this is why amicus briefs can be important, is the court has one particular factual situation and snapshot before it. So in this case, the manufacturing of some of the components had moved over to the United Kingdom. And so when you looked at it in that frame, there was, I think, this sense of, oh, what are we doing here? Because surely the UK would have a sophisticated system and there'd be patents over there that would protect it. But then immediately the question came up, well, what about other countries? And so there was a question as to, would that same protection be provided elsewhere? And so when you try to think of what Congress was intending, was it just thinking about activity that might be moving over to the developed world or places where there might be reciprocal patent protection, or was it worried about the effect that would happen if you had places where there really wasn't meaningful patent protection? And so it does, I think some of the discussion of extraterritoriality begs the question, because the patent laws aren't extraterritorial except for when they are. I mean, this is a provision that we think is carefully structured so the actual conduct it targets is the domestic conduct that's feeding overseas. But it was being passed. The original bill also had the precursor, it wasn't passed until the next year, of our provision that says if you practice a US method patent to create a product, and so all of the infringement of the patent happens abroad, and then you try to import that product into the United States, we have liability there too. So I think you also have to sort of put your mind in the period in which Congress was really concerned with U.S. innovation. It was a period where it was trying to strengthen across the board. It passed that provision I just mentioned, passed 271F, created the Federal Circuit, passed the Bayh-Dole Act. It was trying to bolster patent rights across the board. And so I don't think it would be surprising to see Congress wanting to target domestic conduct that might be sort of seeking out and trying to exploit loopholes that might exist in foreign protection.
Now, there's no doubt that Congress wanted to close, and when you say loophole, that assumes that you think that there are holes, right? You could also argue whether that's the appropriate territorial limit of a patent right. So that alone, when Congress says that, they reveal their normative bias. There's one qualifier I have on that is that 271F is very exceptional internationally. 271G is actually obligated under our international treaty obligations, the TRIPS agreement. And so it is still a fairly unique provision, even internationally. And so I think that's why it raises the specter a bit more of inconsistent laws or differing laws around the world, and that some other countries may not offer those protections. Right? If you think about the reciprocal dynamic, how would we feel if some other country was finding people liable under patent infringement in those countries for activities and exportations to the United States? How does that play out in our own thoughts, right? So those types of conflicts do arise. And again, that's why my position has always been, particularly in the patent space, where there is a decent level of harmonization in a lot of other areas, that if we're really worried about those conflicts, actually just look at them right here. If there is no UK protection, no offense to petitioners, I'd be fine with liability in this context, right? Because that specter of conflict doesn't arise. And so, but clearly they are concerned about, and again, this is their broader concern outside of the patent space as well, of using US law to regulate activities beyond U.S. borders, even if there is a territorial hook here at being exportation. In other cases, it's usually there can be substantial effects tests or whatnot.
Yep.
I'm sorry if this kind of gets too into the biotechnology aspect of it, but was there a disagreement between the two sides over which one of the F1 or F2 statutes applies to this Taq polymerase?
Well, I can tell you that at the trial, that was really an interesting question. If you look at the public record, which is all that I can speak to here, it wasn't necessarily clear what direction Promega was going in. Were they going to try to prove their case under F1, or were they trying to prove their case under F2? And it became clearer, later in the proceedings when it was discussed with the court, and then obviously in the JMOLs afterwards, we got some clarity. I think there was not any evidence, or certainly not sufficient evidence, I don't think, to support a case under F2, especially for the Taq polymerase, because everybody agrees that's a commodity component. So they were stuck with F1. And then the question is, what evidence did they have to support it under F1? And then from that, the notion is, if F1 doesn't cover single components, then you get nowhere with the Taq polymerase as the single component that's coming out of the United States.
Wasn't there some discussion today about how special the Taq polymerase was?
Well, it is, but I think one of the things to understand about F2 is it's an exceptionally difficult standard to meet, because not only are you talking about a specialized component, but you're talking about something that doesn't have substantial non-infringing uses. So the example that was given today, to go back to my pill with the one active ingredient that's doing the work and a few inactive ingredients, the substantial non-infringing use for that active ingredient could be the injectable version of the same drug if it's not covered by that patent protection. And so it can be very difficult to get in under F2, and so potentially leaves a big gap between F2 and F1. And the other thing in terms of the instinct of what was Congress trying to reach here, what F2 can capture. So in some ways, F2 isn't perfectly aligned with the importance of the component, because in some ways the really important stuff may be so amazing that it has multiple uses. Where F2 can snag you is on the stuff that's really highly specialized. So if you picture a car and it has 10,000 components in it, there may be one piece of the car radio or something that's just very unusually configured and is particularly unique to that car. And under F2, that can get you for the whole car. And the way we see these two as working together is, yes, that situation, there can be liability. But once you leave that situation, Congress didn't mean to swing the pendulum all the way to the point of providing everything. What it was saying is, once you leave that situation where you don't even have to prove active inducement, you get into a situation where you have to prove inducement, and it has to be all or a substantial portion, but that doesn't mean going all the way, and can consider a mix of importance. And we give the example of, there's a lot of talk of the single component. Picture an invention that has 10 components and 3 are really important. This is more like the quanta example. And if you asked anybody, they'd say those 3 are more important than all the others put together. The difficulty we have with a strictly numerical rule is you'd swing. If those 3 if each of those had some other non-infringing use, so you couldn't get those under F2, you would have this big gap in the coverage that Congress protected between F2 and F1, and we think that that sort of wouldn't have been the intent to leave that loophole in the coverage they were providing, and also is out of step with the inducement contributory infringement historically, which have had tremendous overlap. And so there would be nothing unusual about one component potentially being covered under both provisions in the right circumstances, because there's a big historic backdrop for overlap.
I think some of this is that, when you look at Deep South and you look at when you talk historically about components, it is more traditionally mechanical. And so here it does apply clearly to sort of the pharmaceutical and the biotech context. I disagree that it creates this big gap, right? Because in some of the circumstances they gave, it could very well be, it depends what the patent covers, right? And so if the patent covers that compound, and then you're in 271F1, you're not in F2, right? And so then you don't worry about substantial non-infringing uses, because if the patent covers the compound, then you're in F1. That's the entire patented invention, right? And the other pushback that I give is that a couple, and remember, I'm not in this case, I'm just amicus, right, is that Congress made it clear for F2 to create that safety valve. So instead of saying it wouldn't want this gap to be there, to me, it's very telling that when dealing with a singular component, Congress created a safety valve to make sure that exportation of things that are generally commodity products aren't going to trigger liability, right? It created the safety valve. If you allow 271F1 to ensnare single components, you lose that important safety valve. And I think that Congress wouldn't have intended to we'll create the safety valve in one context, but then let 271F1 swallow it in every other context. To me, that becomes problematic. And there was this discussion about the parallels between active inducement and contributory infringement, which are clear, and that's clear from the legislative history. The F1 tracks 271B, F2 tracks 271C, but recognize 271B and C require an active direct infringement, right? So eventually everything has to be there. And for me, that suggests 271F1, if it's tracking that, yes, you've got this added requirement of an exportation of something, so, all or substantial portion of the components. But the law is clear, you don't actually have to have to have assembled anything, right? Waymark makes it clear that the actual assembly is not required for there to be liability. So for me, the comparison to 271B pushes you towards a much more stringent standard of having to have almost everything there if it's really becoming analogous to inducement, because inducement requires an active direct infringement. 271F1 technically doesn't even require the actual assembly of the component. So to me, if we think of extraterritorial protection as somewhat exceptional in the U.S. patent law, we should be very careful about suddenly robustly interpreting those provisions.
Just from the work that Agilent did in exploring the background, it's very clear from the Deep South decision that 271F was intended to be a very small extension to 271A, which is about infringing the invention in the US. And so if you, in those cases, you didn't infringe the invention because you didn't actually assemble it into one invention, you were shipping components. So I think that there is a lot of truth to the idea that it's okay for there to be some room, and even maybe a lot of room, between the scope of 271F1 and F2, because that's what Congress decided. They wanted a small extension of 271A and a small extension of 271C, where you were sending this key component only suitable for infringing, plus instructions to infringe.
Any other questions?
So some time ago, Congress amended the Patent Act to get rid of the judicial interpretation of it was obviousness, looking at the gist of the invention or the heart of the invention, and put it back to looking at all the components of the invention. 271F1 goes back to talking about components of the patented invention. Are we starting to see from the Supreme Court where they're slipping back into looking at the heart of the invention or the gist of the invention from Mayo and from maybe this case, well, although we don't know where this case is coming out yet?
Yeah, I think the answer, there's a lot of nodding going on. I think the answer is yes. I mean, if you look at Quanta, Quanta does that as well.
101.
If you look at all the 101 analysis, really looking at what was inventive, what was the inventive concept, right, in Alice. So I think absolutely the court is going back there, and that's where they're leading the law.
I think the court really thinks that it had been dogma in patent law for decades that the claim is your invention, right? That is what defines the invention. The Supreme Court has kicked that to the curb, right? You saw it starting clearly in the 101 cases, clearly in Quanta, although Quanta at least has a strong antecedent basis with the Lens case. I'm reading the name, right? But yes, right? I mean, I consider the Alice step to be patent deconstruction, right? Where you're determining is it directed to this sort of abstract idea, and you take the claim and you generalize it in some way. And so the Supreme Court definitely thinks that the invention is distinct from the claim, but they haven't given us a lot of guidance on, well, then what is it actually if it's not the claim itself?
Yeah.
But hopefully they don't do it in this case.
All right, so welcome. Join me in thanking the illustrious panel for their comments. We'll have a reception outside. Is that right? Yeah, we think that's right. And you're all welcome to join us out there. And make sure you take your umbrellas.
Especially on scale.
Yeah. Thanks, Don. Yeah. Let's see you again. Thanks.
Yeah, it's been crazy. That one's drug exclusivity, but it's the non-patent exclusivity.
So Kathleen was my
Your students are all into.
Yeah, the Supreme Court doesn't have a lot of respect for finals period. Today was the first day of tests, so.
Yeah, no, you weren't a cinder gun.
Yeah. Pretty impressive.
She's not. No, she's not.
I got there. We got there. Man, that was way.
Even I wasn't getting this argument.
So you're doing litigation?
They were laying tourists who normally only get to stay.
Yeah, they're letting
back.
working
Tourists cycling.
A lot of partners.
Yeah.
Sorry,
No problem.
like I don't know what NT. I don't see a building.
At least you were in the building. I was stuck in a cab.
Texting.
Closing
argument. I was texting.
Well, yeah, I should have warned you this.
Oh, yeah.
Oh, good. Good.
Oh, great. Okay.
No. That and the building is so. I can't even. There's something in there. Yeah,
Because for you,
this is.
only have Y, for capital C, or
Yeah.
but still like this really better.
Okay.
So the thing is, Apple, Samsung was our case.
Yeah, I know. I was thinking of you when they announced that. I was like, you were pretty good. No response. That was pretty good.
No, I mean, so
After you.
Apple, Samsung.
Everyone just.
And it just was this fight
Yeah.
over like, is that how they tried the case? Is this waived? Is there
I mean, that argument is so weird. And the justices were all over the map about what are we deciding? Are we deciding the case? Are we deciding what the judge did below? In this case, they were much more focused on the issues. Like in Apple Samsung, they didn't really know what they were doing.
because there was no legal question left for them to decide. There was agreement. So they basically.
It's more complicated
Yeah,
than you.
everything. I'm impressed. You're the one student I noticed that out here. Well, during finals.
I was gonna say it's
Yeah.
exams, right?
Yeah, I needed a break from the work.
Yeah, she's a 1L, so it's pretty impressive. This is Tim.
It's very nice to meet you.
So you're saying
Tom, nice to meet you.
Tom, did I say your name right? Is it Saunders or
It's
Sanders?
Saunders, yeah.
Okay. So,
Like those were the older people were my parents who lived nearby.
Oh, really?
So it was my dad.
Yeah.
So it's good. But yes, you're very good.
well, apologize to him.
No, yeah, no worries.
Well, we have to take a break eventually. You can't.
Yeah.
We really
Your brain feels full. You got to take the bar you're in for that. Once you graduate, take the bar exam. There's moments like, can't do this anymore. I
Yeah.
can't do it. I need to get away. Yeah.
Yeah.
Although I don't know that coming to a panel discussion on
Where to put it.
just would have been high.
It gives that perspective of like, why am I doing this again? Oh yeah, this is why I'm doing this.
Yeah,
This is
yeah,
why I'm here.
yeah, yeah.
Gives you that big picture. But
Good.
have a nice day, Professor Anderson.
All right.
Nice to meet you.
Nice to meet you.
See ya.
Yeah, I got asked to write up something about the Samsung case. It was like, because Supreme Court, just like about that just kind of thing. It's like, because Supreme Court said nothing, right?
Nothing, yeah.
I mean, they even said, here's the two things that need to be decided. Ours is sort of about the first, but that's all we're going to say.
Yeah.
The opinion could have been 2 paragraphs.
Yeah.
The history of the statute. Like, this is irrelevant.
Yeah. So in many ways, that was what like Apple's.
Yeah, I know, you do.
It
Say
was
it's a bunch
so
of trial lawyers that get together to chat.
And
then a commercial reality.
They've sent it down
One
to
of
the
our
federal
corporate
circuit,
Yeah.
and they've made. I mean, obviously, it'd be better to confirm, but they left it.
I think
there
even
to the
from the federal circuit,
they've
they'll
got it
probably remand it again. Maybe with instructions,
Right,
but
it depends. How much guidance they want to give Judge
Yeah.
Coe, or do they just send it her to do it all in the
Yeah.
first instance? And,
Yeah.
yeah. Because it's not like they have anything to hang their hat on in the opinion to say, like, well, here are things that we think you should look
Yeah.
at, but it would still stink for Judge Coe to be like, well, I'm going to sort this out and then hope I don't get reversed on appeal. Right?
Again.
Right.
Yeah.
No, but they'll have stuff just because.
Yeah.
Okay. I mean, if you
think
sense
they're
Like
gonna
the other
the
side's
patent,
expert.
here, make this.
Yeah.
Our damages theory was on the whole.
No.
Like,
So they're gonna have to redo it.
he didn't submit. Well, or that was the article of manufacture. I mean, that in other words, the fight was they never
There were-
contended that anything other than the whole thing was the article of manufacture. The federal circuit sort of
They didn't really go.
they didn't get it was
about
2
that either.
paragraphs at the end of
Yeah.
it. It was sort of such a sideshow in the entire case.
What, sort of like, yeah.
And then it sort of moved to the center with the newfound legal theory, which just sort of even evolved while it was in the Supreme Court.
Yeah.
So,
Yeah, that surprised me, the argument when they're like, no, we agree, article of manufacture. I'm like, okay.
yeah.
That's not going to give them a lot to play with. Then, right? So, and then, right, and I have a feeling even for step 2, doing the valuation, I think they're going to start looking at deportment law as a utility patent.
Yeah.
Right.
Yeah. What did you think about? Well, let's step away from the mic. So
Yeah.
what do you think about?
Seth kind of got slapped down by the chief when he put off Sotomayor. He said, "I'll take your questions."
Yeah.
I mean, it's been. She said, "I think your sentence is over."
Yeah. No, I talked to them about that. I mean, it's the sort of leeway of the former Solicitor General, but it was giving sentences. And so I described to Seth the scene that he was not seeing, which was sort of 1 sentence, and then became 2 sentences, and the chief sort of looked up, and then became 3, and he leaned in, and then became 4, and he leaned in, and so we're done. So yeah, that wasn't great.
I knew as soon as he said, like, "Let me ask you a question in 1 sentence," I was like, "I don't think you can do that."
Yeah, I looked at the disparity because I was all this stuff about once you get to that territory questions, now the Chief Justice is doing is actually directly relevant to a paper I'm writing. So I was like, well, let's drop the footnote. It's not a damages side of it, right? But I'm like, let's drop the footnote that like he actually agreed with me on that. Yeah.
To me, the most interesting thing, so the chief was sort of expressing the pushback of extraterritoriality. To me, most of it is just when Justice Breyer was saying, sort of stop talking about
Hey,
extraterritoriality.
don't we need
talk about
to
the
get our
policy.
thing
Like,
on
he just thought
file?
that, like,
Meaning
you're not
we have
making
to
what
see
he
what,
was most
it's
keen on.
5:20.
Right. Yeah. It's hard to read. They're all coming at it at different angles in some ways, but engrossed in a way that I was pleasantly surprised.
And then Kagan was saying, like, she didn't like, who are for the other side? Carter. She didn't like his interpretation of F2. She thought it was way overboard. She kept pushing back on that. And
It's 5:20. I mean, that's called not giving us a chance to review what's going to be filed, which is not okay.
The substantial, there's 2 questions that are, I think, pregnant. Her question and the question about breach. Number breach is it quantitative?
Yeah, well,
Quantitative.
it's not just see it. We need to
Right, so
consider it.
substantial could be
This is supposed to be a joint submission.
context, like substantial could be, like that could be substantial, right? 15% could be substantial in some cases. That still leads you to almost all, which is what the petitioners want, right? So you have substantial.
Yeah, you need to do it immediately.
Even if it's quantitative.
I thought
Right.
I was so kind of shocked by the difference between the government's argument about what the standard should be. It could have changed that in the argument, which is what you're saying, and what what the life was arguing for. Life was basically arguing like it had to be all the components, like or tantamount, or just like synonym for all. And then the government was saying, well, it can't be one, but then it's something
They know at this
something
point.
wrong.
Just
Yeah,
can't be
I think
one.
so
here's
Right.
here's what makes it even screwier. Life's position at trial was the line is between 1 and 2 components. So their rule was you have to supply multiple components. It cannot be one. But they specifically said to the judge, for the kits with 2 components, those can go to the jury. Like they waived the issue, and this whole like nearly all never entered the case until the government's invitation when it said that, and then Life now has wholeheartedly embraced this, and then suddenly the government was backing away from it, and Life was still.
I read the government trying to thread the needle, right? That you can get rid of this case on the more than one, and you don't have to really answer the rest of it without it, right? And that gives you a way out without giving my
For all the twos.
Well, so here's the screwy thing. It was sent back for a new trial anyway. Because there were 5, or maybe, there were 5 patents in the case. And there's 4 got knocked out by the Federal Circuit. And so then there was a fight on remand as to whether a new trial was required or whether, because the one everything infringed, the one that was remaining, I think was the broadest. And so when we were opposing cert, we were just sort of like, why would you take up this question now when the other side is saying they're entitled to a new trial no matter what? And by the way, there's been all this evidence that's come out after the trial. And so when we do this new trial, we're going to be proving that they had multiple components for all of these. And so, like, what are you doing here? So.
Well, but at least you get a clear test before you go to trial.
Yes. And we may not go back. We have positions, so we'll see. And then the other thing, too, is that there's just a huge chunk of United States sales. My jaw dropped. Carter got out there, I think he just misspoke. He said these aren't sold in the United States.
Oh, I missed that.
Yeah, he said it right near the beginning. And I was just thinking, like, no, I mean, even when 271F drops out of the case, you still have several $100 million of U.S. sales. Like, it was like U.S. sales are half the worldwide sales. So there's definitely a trial on the U.S. side, too.
Okay. Rob? Hi. Joe, thanks. Nice to meet you.
Well, thank you for your history. For coming out.
Made the right decision.
See, what I was amazed at just after this is their 22nd patent case in 6 years.
Yeah.
And they still seem to be stumbling over some basics. Like, yes,
that was a lot better today.
No, it was a lot better.
Yeah. Sotomayor, she recognizes what she doesn't know, so that's a good.
Right, and then it's very good that none of these actually involve the technology, because when Taq polymerase was being called the polymer, I was just like, no.
Even Seth said that.
Seth he repeated polymer.
I thought he was trying to be polite.
I still remember back in the day, the first question on Warner Jenkins was, what is pH? And I was like,
We're in trouble.
No. And they still got it wrong, actually, because then on remand, the Federal Circuit drops its footnote, giving him a chemistry lesson on what pH actually is, right? It's like, so I didn't leave. And so in fact, too, when Justice Ginsburg insisted there was no such thing as a constructive production of practice, like, actually there is, and it's a term of art, right? And so I think that's why you don't see that reference to the ready for patent standard. It's because she said there's no, it's either ready for practice or it's not. There's no such thing. It's kind of helpful, actually, that they use that terminology in some ways.